Hi guys, it's Melissa again. This is part 2 of my dispute resolution series under IDEA, which is the Individual with Disabilities Education Act. I've already talked to you in part 1 about facilitated meetings and mediation. All of these remedies that I'm talking about in this series are available to you if you are in the United States, because IDEA is a federal law. They are available to you and you just have to request them through your state office of education. So the next remedy, we first had facilitation, which is sing kumbaya and try to get along. We then have mediation, which is where a bigger decision maker attends and weighs the cost of fighting you versus just giving you what you want. And then the next level is a state complaint. Now, what happens with a state complaint is you go in and fill out, you can either fill out a form, sometimes they have a form online. I prefer to actually write a letter, and you describe what's happened or what the dispute is. You describe the ways that you think that violated IDEA. So that's where your special ed law book comes in handy big time, because you can actually give the legal citation. You can look it up in the book, and give the legal citation of what they violated. You present any exhibits that go with that. So maybe an IEP, maybe some meeting notes, maybe a recording of a meeting, maybe some emails. And then you ask for whatever remedies you're asking for. So those remedies can be, look, they're not going to provide this to my kid, or the services they provide are crap. So I want, if they're found in violation of this, I want private services. You can also just simply ask that they have formal training. It's kind of that they have formal training, because they don't know the law. So it's a little bit of insulting to them, but at the same time, if they don't know the law or they're not following it, and they're found to be in the wrong, they should automatically get formal training, but you would be surprised. So you have to outline everything, and then you submit it to the state. And it used to be that they'd have so many days to respond, and then you could respond to their response, and then the state would look at everything. They've streamlined it. Now you submit it to the state. You also have to give a copy to the school system. And then I believe it's 60 days that the state tries to get a response from the school system and looks at everything and gets back to you. Now, I have actually seen it where the state has ordered corrective action. Corrective action. They've actually gone in and said, school system, you're wrong. I've also seen it where the school system has been wrong and the state has carefully talked around it enough to let me know that maybe what happened was questionable, but I have suspected that behind the scenes, they've been calling up the school system going, what are you doing? Why are you doing this? So it's a way for the state, who is supposed to be a neutral third party, to look at an issue and try to decide from an independent party if they feel that corrective action needs to be done, or if they feel that the school system did what they should have. It can be a powerful tool. School systems don't like it. Sometimes you will win, sometimes you won't. Sometimes you win and you don't know it, because like I said, I believe there's a lot of reprimanding that happens behind the scenes that you may never know about. But it's a really great way to flash a big light on something that you don't agree with. And so that is the third remedy that you have, which is a state complaint. Stay tuned for part number 3, which will be about the final dispute resolution option that you have. If you haven't subscribed, please do so down below. I just hope that you'll learn from this, that you'll get those special ed law books. I'll try to link those down below, and you'll be able to use your dispute resolution rights to help advocate for your kid. Until next time, make it a great day. Bye.